Good evening to Honorable Justice M. Sundar Justice, Honorable Justice B.B. Balaji Justice, Honorable Justice R. Saktivel Justice, and Honorable Justice V. Lakshmi Narayanan Justice. And good evening to everyone. I request the President of Women Advocates Association J. Anandavalli ma'am to deliver the welcome address.
Good evening to all. We are happy to have Honorable Mr. Justice M. Sundar in today's lecture. Cornelia SORABJEE lecture series was inaugurated by Hon'ble Mrs. Justice Tahil Ramani, Chief Justice of the High Court, in the year 2018. And from then onwards, we are organizing lectures. Speakers are from judges and as well as by members of the bar. When myself and our secretary, Mrs. Krishnaveni, met Honorable Mr. Justice M. Sundar to give a lecture in our association, His Lordship immediately consented for the request, and he has said about the topic. When I started giving invitations to members of the bar and also to the honorable judges, the reply from all of them are, from the judges part of it, excellent speaker, it's a lecture to be heard, because some of the judges had an experience of attending in the Judicial Academy. Members of the bar who have gone through Honorable Justice's lecture in the YouTube thanked us for organizing this lecture. It is a member of the bar request is, it is an $1 million lecture which has been topic suggested by Honorable Mr. Justice M. Sundar. I welcome your Lordship before this August gathering. I welcome Honorable Mr. Justice P.B. Balaji, Honorable Mr. Justice Saktivel to this lecture. I welcome all the members of the bar here, and particularly women advocates, my friends, and all members who are present here. Thank you. Thank you.
Thank you, ma'am. Now it's time to honor our Honorable Judge. I request Mrs. Prabhahari, Librarian, to honor Honorable Judge Mr. Sundar. I would like to call upon Honorable Mr. Justice M. Sundar to give the lecture the topic of the Commercial Codes Act 2015 and the Code of Civil Procedure 1908.
Honorable Justice Balaji, Honorable Justice Shaktivel, my bench partner, Ms. Anandavalli, President of the Association, Krishnaveni, General Secretary of the Association, Ms. Prabhakari, Librarian, Treasurer, Librarian of the Association, and all the other learned members of the bar who have taken time off on Diwali Eve to be here. Good evening and greetings. Malay Vanakkam. At the outset, let me make two aspects very clear. A, this is not going to be a lecture in the real sense of a lecture. Definitely not the SORABJEE series lecture. It is not going to be esoteric, because that was the request which Anandavalli and Krishnaveni made to me. They said the fundamentals and first principles of Commercial Codes Act, particularly for district court practitioners, is very important, and please tell us something about it. That was the remit. That is the remit under which I'm here. Therefore, we can make it interactive. This is one aspect. The second aspect is, I intend going bilingual to the best of my ability, at my command. And we will try to make it very interactive and a little informal too. Not very formal, not completely informal either. So this is what I propose to do. The purpose of this topic is very, very simple. It is not to bore you with Commercial Courts Act 2015, the nuances, a large number of judgments on the same, and tell you some fine points of law. That is not the objective. The objective is to tell you that this Commercial Courts Act 2015 is just a procedural law. அது ஒரு நடைமுறை சட்டம் அது மட்டுமே. It is not substantive law. Number one. Number two, any lawyer in the trial court, விசாரணை நீதிமன்றங்களில் இருக்கக்கூடிய எந்த ஒரு வழக்கறிஞரும் இந்த வணிகவியல் வழக்குகளை விசாரிக்கும் நீதிமன்றத்தில் எளிதாக வழக்குகளை நடத்தலாம். இதில் புதுசா தெரியறதுக்கு எதுவுமே ரொம்ப சப்ஸ்டான்டிவ் லா இல்ல, சப்ஸ்டான்டிவ் லாவே இல்ல. நீங்க ரெகுலரா ட்ரையல் நடத்துற ஆளாக இருந்தா, நீங்க சிவில் கோர்ட்ல ட்ரையல் நடத்துற ஆளாக இருந்தா சிம்பிளா கமர்ஷியல் கோர்ட்ல ட்ரையல் நடத்தலாம். This is what I am going to, this is the objective of this lecture. Very simple. With this purpose, that is why I said it is going to be less of a lecture and more of first principles. Now, those who go to civil courts, now one of you, please tell me, what are the statutes you deal with? Anybody who goes to the civil courts, what are the statutes, what are the acts? Anybody who goes to the trial court regularly, who conducts trial, or anybody who is a civil law practitioner, forget trial court. Anybody who is a civil law practitioner, right? Evidence Act, right? That is procedural, more of course, substantive is there. Yes, then. Sorry? All right. இல்ல ஒரு சூட் அப்படின்னு வந்துருச்சுன்னா, ஒரு தாவா அப்படின்னு வந்துருச்சுன்னா எந்தெந்த சட்டங்கள்? இல்ல அதெல்லாம் ப்ரொசீஜர். நான் ஒரு 7 சட்டங்கள் சொல்றேன், சரியா வருமான்னு பாருங்க. கான்ட்ராக்ட் ஆக்ட் 1872, இந்திய ஒப்பந்த சட்டம் 1. 2, ஸ்பெசிபிக் ரிலீஃப் ஆக்ட் 1963, குறிப்பிட்ட நிவாரண சட்டம். 3, டிரான்ஸ்பர் ஆஃப் ப்ராப்பர்ட்டி ஆக்ட் 1882, சொத்து பரிமாற்ற சட்டம். 4, இந்தியன் ஈஸ்மென்ட் ஆக்ட் 1882, இந்திய வசதி உரிமைகள் சட்டம். அடுத்தது பார்ட்டிஷன் ஆக்ட் 1893, 6, பாகப்பிரிவினை சட்டம். அடுத்து சேல் ஆஃப் குட்ஸ் ஆக்ட் 1930, சரக்குகள் விற்பனை சட்டம். அடுத்தது நெகோஷியபிள் இன்ஸ்ட்ருமெண்ட்ஸ் ஆக்ட் 1881, மாற்றுமுறை ஆவணங்கள் சட்டம். Broadly, எவிடன்ஸ் ஆக்ட் அண்ட் சிபிசி ப்ரொசீஜர். மற்றபடி சப்ஸ்டான்டிவ் லானா predominantly these 7 statutes cover any civil suit. Contract Act 1872, Indian Contract Act 1872, Specific Relief Act 1963, Transfer of Property Act 1882, Indian Easements Act 1882, Partition Act 1893, Sale of Goods Act 1930, and the Negotiable Instruments Act 1881. That's all. As regards trial or an appeal under 96, why even a second appeal under 100 of the CPC, you may have to have some knowledge about Evidence Act and CPC. That's all. Take it from me, there is no change in any of these statutes in the commercial court. Absolutely no change. Same Contract Act, same Specific Relief Act, same Transfer of Property Act. Let it be an infrastructure contract running into 200, 300 crores. Let it be a trademark suit. Let it be a copyright suit. There is no difference in the statute. This is all which you know already. As between a commercial court and a regular civil court. Now let us take an illustration. Let us take a simple illustration. Let us say it is a suit for specific performance. There is an agreement between a builder and a landowner. Builder is B, landowner is A. The builder agreed to develop the land, put up apartments there, share the superstructure, brick and mortar superstructure and the land on a 50-50 basis. Simple, very simple basic agreement. There is a contract for the same. There is alleged breach of contract. There is a specific performance suit. There is claim. Simple. This will go to the Commercial Court Act. Commercial Court. If you can conduct the suit in the regular court, you can conduct it in the Commercial Court also. The reason is, you may ask, then why does it go to the Commercial Court? One. And what is the difference? I will tell you in very, very simple terms. The difference is in CPC, that too not much. CPC consists of 158 sections, 158 பிரிவுகள், 52 orders, 52 கட்டளைகள், அட்டவணை ஒன்றில் அந்த 52 கட்டளைகள் இருக்கு உங்களுக்கு. 52 orders அட்டவணை ஒன்றில். பிறகு 8 பிற்சேர்க்கைகள், 8 appendices, A to H. இவ்வளவுதான சிபிசி? This all 158 பிரிவுகள், ஒரு அட்டவணையில் வந்து 52 கட்டளைகள், 8 பிற்சேர்க்கைகள், A to H, A B C D E F G H. இவ்வளவுதான் சிபிசி. இதுல 3 பிரிவுகள், 3 out of 158 sections, 3 sections, 10 orders have been amended by the Commercial Court Act. That's all. This entire act is only that. Nothing else, nothing more. And of the appendices, in addition to the existing 8 appendices, 1 appendix has been added. 8 பிற்சேர்க்கைகள், A to H இருக்கக்கூடிய 8 பிற்சேர்க்கைகளுடன் இன்னும் ஒரு பிற்சேர்க்கை உண்டு, அது I. A to, that's all. This is the scope of Commercial Courts Act. Therefore, the first and foremost point which I want to emphasize is, please do not fear this act. Any lawyer familiar with the civil court at any tier can deal with a matter in the commercial court, commercial division in the principal. See, there's no commercial division here in the Madurai bench, or any appeal arising out of the same, without any hesitation. Nothing to fear. Now what I propose to do is, I've just prepared a PPT wherein I'll ask them to circulate to you. You can keep it with you to tell you what are these 3 sections, 10 orders and 1 appendix. That's all. And that I put it in the form of a tabulation to say what is the existing section, what is the amendment that has been brought about by the Commercial Courts Act, and what is the impact. We'll just see 1 or 2 of great importance, and the rest I'll just circulate it to you, because ultimately CPC itself is procedural and it is a change in the procedure. That's all. In this, before I do that, before I take you through this tabulation, now how do you decide whether a particular suit goes to the regular court or it goes to the commercial court? ஒரு வழக்கு, ஒரு சிவில் வழக்கு நீதிமன்றத்தில் தாக்கல் செய்யப்படுகிறது என்றால், அது சாதாரண நீதிமன்றத்தில் தாக்கல் செய்து இந்த அமெண்ட்மெண்ட்ஸ் இல்லாத சிபிசி, கமர்ஷியல் கோர்ட்ஸால அமெண்ட் பண்ணப்படாத சிபிசி ரெகுலர் சூட்டா நடத்தணுமா, அல்லது கமர்ஷியல் கோர்ட்ல தாக்கல் செய்து amended CPC பயன்படுத்தணுமான்றதை எப்படி முடிவு பண்ணுவீங்க? How will you decide? Sorry? Yes. இதுக்கு just want, see the jurisdiction, another aspect. இதெல்லாம் வந்து more of semantics and nomenclature தான். The district court commercial courts are called commercial courts. If it comes to high court original side, it is called commercial division. It is one and the same. You know that the original site is the district court for Madras. Simple. Therefore, when somebody says commercial court or commercial division, don't get bamboozled. Nothing in it. The district court is called commercial court. The original site court is called commercial division. For a suit to be filed in the commercial court, two things are required. Two things, and conjunctively, rendume irukkanum. One, it should be a commercial dispute. Two, it should be of specified value. Rendume defined terms. Commercial dispute is defined in 2(1)(c). Specified value is defined in 2(1)(i), read with section 12. Instead of even going through, I will tell you in very simple terms what this is. Commercial disputes, if you see 2(1)(c), let us read it if you have the book with you. I am not going to take you through each one of the provision and bore you. Definitions. 2 is definitions. 2(1) says, in this act, unless the context otherwise requires. I am skipping A, B and going to C. Commercial dispute means a dispute arising out of, you will find 21 plus 1, 22 categories. I am saying 21 plus 1, 22 because 21 are specified categories. And 22nd says, such other commercial disputes as may be notified by the central government. Simple. Rest are all, if you see, 2(1)(c). For instance, let's go to 2, let's skip 1, let's go to 2. Export or import of merchandise or services. 3 is issues relating to admiralty or maritime law that may not arise in the commercial code. Then carriage of goods. Then construction and infrastructure contracts including tenders. So if it is a commercial dispute falling under any one of these 21 categories, namely, commercial dispute means a dispute arising out of one of these 21 categories. As regards 22, central government has not notified any category. So therefore, it should be a commercial dispute under 2(1)(c). Number 2, it should be of specified value. Specified value is under 2(1)(i). Come to 2(1)(i). Specified value in relation to a commercial dispute shall mean the value of the subject matter in respect of a suit as determined in accordance with 12. Don't worry too much about 12. 12 is only computation, is only the method of computation, which shall not be less than 3 lakhs or such higher value as may be notified by the central government. Inga, you just have this in mind. If it is a commercial dispute under any one of the 21 categories under 21(c), அதாவது அந்த வழக்கில் இருக்கக்கூடிய பூசல், the list, அந்த வழக்கில் இருக்கக்கூடிய பூசல், the list, if it falls under any one of these 21 categories under 2(1)(c), it becomes commercial dispute. And if the value of the suit is more than 3 lakhs, it goes to the commercial court. And when the Commercial Courts Act came in 2015, 23/10/2015 to be precise, this 2(1)(i) was 1 crore. 1 கோடியாக இருந்தது. Thereafter in 2018, an amendment was brought in, 3/5/2018 to be precise. That is when that 1 crore was brought down to 3 lakhs. That is why those of you who have the book will find that which shall be not less than 3 lakhs is within parenthesis. And if you see the footnote, it will say substituted for which shall not be less than 1 crore V-Day such and such with effect from 3/5/2018. Footnote. அதனால 23/10/2015 1 கோடியாக இருந்தது. இந்த சட்டம் இயற்றப்பட்ட பொழுது, இந்த சட்டம் அமலுக்கு வந்த பொழுது, இயற்றப்பட்டதுன்னு சொல்ல முடியாது, முதல்ல ஆர்டினன்ஸா இருந்தது. அதனால இந்த சட்டம் அமலுக்கு வந்த பொழுது 23/10/2015 1 கோடியாக இருந்த ஸ்பெசிஃபைடு வேல்யூ 3/5/2018 இருந்து 3 லட்சமாக குறைக்கப்பட்டுள்ளது. So if it is a commercial dispute of specified value, it goes to the commercial court. Simple. இது எங்க சொல்லி இருக்க ஆக்ட்லன்னா section 6. Let us look at section 6. The PPT we'll have the later. We'll keep. I'll tell you because that will be distracting. We'll run through quickly. We'll run through. Section 6 is jurisdiction of commercial court. Let's see how the jurisdiction is. The commercial court shall have jurisdiction to try all suits and applications relating to, this is the catchword, a commercial dispute of a specified value. 21C, read with 21I, 21C and 21I. A commercial dispute of a specified value arising out of the entire territory of the state over which it has been vested territorial jurisdiction. Then of course explanation is, for the purpose of this section, a commercial dispute shall be considered to arise out of the entire territory of the state over which the commercial court has vested jurisdiction, if the suit or application relating to such commercial dispute has been instituted as per the provisions of 16 to 20 of CPC. Now, pending suits can also be transferred. The provision is 15(4). If it is a commercial dispute of specified value, it gets transferred to the commercial court. Then you might ask me, then we'll run through the PPT quickly. Then you might ask me 2 questions. Why these amendments to the CPC, and why separate commercial courts, and what is the effect of these amendments? These are the questions which will arise in your mind. Why this act at all? Why a separate court? And what would be the effect of these amendments when applied in a commercial court? The simple point is to expedite the trial. Commercial Courts Act is devised in such a manner that if the amended CPC is applied, the suit will be completed in 11 months. Several provisions are already there. But for instance, written statement to be filed within 90 days, 2002 amendment. For instance, 90 days kulla written statement file பண்ணோங்கிறது 2002லயே வந்த CPC amendment. இது ஒன்றும் புதுசு கிடையாது, இந்த 120 days குள்ள. But what happened was, இது ஒரு illustration சொல்றேன். இந்த 3 sections, 10 orders and ஒரு appendix எல்லாமே வந்து already இருக்கிறதா. It is given in the form of Commercial Courts Act. அவ்வளவுதான். அதுக்கு இத உதாரணமா இந்த ரிட்டன் ஸ்டேட்மெண்ட் ஃபைல் பண்றதுக்கான டைம் ஃப்ரேம் சொல்றேன். 90 days கொண்டு வந்தாங்க, எல்லாருக்கும் தெரியும் இல்லையா? 2002ல the CPC amendments were challenged. All of us know Salem Bar Association. Salem Bar Association, when it went to Supreme Court, Honorable Supreme Court said this within 90 days is only directory and not mandatory. The reasoning was to test whether a particular provision is directory or mandatory. The test is, please see whether there is a consequence. If there is a consequence, it is mandatory. No consequence, it is directory. So applying this test, Supreme Court says 90 நாட்களுக்குள் எதிர்வாதுரை தாக்கல் பண்ணலன்னா கான்சிக்வன்ஸ் என்ன, விளைவு என்ன அப்படின்னு உரிமையல் விசாரணை முறை சட்டத்தில் சொல்லப்படவில்லை. Therefore it is only directory அப்படின்ட்டாங்க. இப்போ 2 வருஷம் 3 வருஷம் 5 வருஷம் கழிச்சு கூட ரிட்டன் ஸ்டேட்மெண்ட்லாம் தாக்கல் பண்ணு. Now you will see one of the amendments here says 90 plus 30, 120 days. Beyond 120 days you cannot file written statement. No, that is the amendment that is brought in. Old 2002 amendment தான். இப்ப என்ன, what they have done is they have provided for that consequence. What is the consequence na, ஒரு டிஃபெண்டன்ட் அந்த 120 நாட்களுக்குள்ள ரிட்டன் ஸ்டேட்மெண்ட் தாக்கல் பண்ணலன்னா 121வது நாள் the plaintiff is entitled to a decree. It is something like your 11(4) of the Rent Control Act. Those of you who are familiar with the Rent Control Act, so pardon me, I should not. So those of you who are familiar with the rent control, I'm skipping. Starting from the second row. 11(4) உங்களுக்கு எல்லாம் தெரியும். Any RCOP for eviction la tenant வந்து 11(4) of the old act. The new act has kicked in now. I'm talking about the old act. If a tenant does not pay the arrears of rent, he loses his right of defense. Likewise, here they say if you don't file written statement in 120 days, you lose your right. And the plaintiff is entitled to decree. Now that a consequence has been provided, the Supreme Court, again the same dispute started, whether it is directory or mandatory. Different high courts took different views. I took the view it is mandatory. Subsequently, the matter was taken up by the Supreme Court. SGS contracts, Supreme Court said it is mandatory. That's all. This is the position. I'll give you the judgment. Similarly, if you see all these amendments, 3 sections, 10 orders and 1 appendix, they are all already there, but now it has been spruced up and it has been given in a particular form. Example is this written statement to be, it's an illustration. That's not the only amendment. That's an illustration which I am giving you to say that all these provisions already existed. In addition to it, those of you who would like to file a suit in the commercial court should now be aware of one provision. That is very, very important. I am trying to make it very practical. I am not making it theoretical. I am not making it esoteric. So, one provision that is a little different from CPC, vastly different from CPC, which all of you should be aware of. Very important provision. அது மட்டும்தான், அந்த ஒரு provision தான். மற்றதெல்லாம் you need not bother. Section 12 capital A. Section 12 capital A. Before I read the section and tell you what happened and how it has now been concluded, very, very recently in Patil Automation and Yamini Manohar, a full bench is in season of the matter in our High Court because of 2 differing views. But nonetheless, the Supreme Court has laid down the law. In the 12 capital A, what it says is, before we read it, instead of reading it and then trying to understand, I thought, well, briefly tell you what this 12 capital A and then we will read it. It says, before filing a suit, a party should attempt mediation. Should attempt mediation. If you see the caption for 12 capital A itself, it will say pre-institution mediation and settlement. Pre-institution mediation and settlement. That is the caption for 12 capital A. In the 12 capital A, was not there when the Commercial Courts Act kicked in. I'm using a slightly loose term, came into force. Said it's informal, therefore I'm taking the liberty of saying it kicked in. When it came into force on 23/10/2015, 23/10/2015 அன்று இந்த வணிகவியல் வழக்குகள் சட்டம் 2015 அமலுக்கு வந்த பொழுது 12 கேபிட்டல் ஏ இல்லை. அதன் பிறகு 3/5/2018 வந்த அமெண்ட்மெண்ட்ல தான் இந்த 12 capital A was introduced. Now let us quickly read 12 capital A. I will spend 5 minutes on this. It's about 6:10. By 6:15 I will complete this and then do the concluding part, and I will not bore you any further. This is of relevance. 12 capital A, let us read it and I will tell you. 12 capital A. Pre-institution mediation and settlement. 1. A suit. which does not contemplate any urgent interim relief under this Act shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner and procedure as may be prescribed by rules made by the central government. 2. The central government may, by notification, authorize the authorities constituted under the Legal Services Authorities Act 1987, 39 of 1987, for the purposes of pre-institution mediation. Therefore, it says a suit which does not contemplate urgent interim relief should not be filed in the commercial court directly, but you should first attempt mediation. It also says the central government should make rules, 1, and the central government should make a notification under 12A2. Rendume pannitaanga. This came into force on 3/5/2018. Central government made rules and issued the notification on the same day, 3/7/2018. The rules say how the pre-institution mediation should be conducted. As regards the notification, you just have to go to the District Legal Services Authority. That's all. In very simple terms. Let us not go through the rules or notification and get too very confused. You have to go to the DLSA, District Legal Services Authority, and seek mediation. Say that this suit notice was issued. He has replied like this. Now, therefore, please take it up for mediation. If you see the rules which have been framed by the central government, which have come into force, that is called the Commercial Codes, within parenthesis, Pre-Institution Mediation and Settlement Rules 2018, which came into force on and from 3/7/2018. Those of you who are having this commercial law publisher's book, it is at page 36. And professional, those of you who are having professional, you will find that these rules are at page 28. I carried both. So, simple. In the rules, it provides for completing mediation within 3 months. Within 3 months. In the 3 மாசத்துக்குள்ள ஒன்னு மீடியேஷன் முடியணும், இல்லைன்னா ஃபெயிலியர் ரிப்போர்ட். இது ரெண்டுமே இல்லாம மூணாவது ஒன்று இருக்கு. இட்ஸ் கால்ட் நான் ஸ்டார்டர் ரிப்போர்ட். Suppose I am the plaintiff in the illustration which we are dealing with between a landowner and a builder. Let us say I am the landowner. I wish I was one, but I am not. So I want to go to the commercial court and say that the builder has breached the provisions. I have to first issue a notice, then go to the DLSA and say, please see, this is the dispute. I want to go for mediation because I intend filing a suit against this builder. Then notice will go from DLSA. Suppose the man doesn't respond at all, receives the notice and keeps quiet. There is provision for sending notice 3 times. We don't have to bother ourselves. You see the rules, you will understand. It's very simple. Already we are dealing with a parent statute, which is a set of rules. It is a subordinate legislation under that parent statute, under 12A1 read with 21. 21 is rule making power. 12A1 says subordinate legislation has to be made by the central government. 3 மாதங்களுக்கு அது 3 முறை நோட்டீஸ் அனுப்பி அவர் வரலன்னா நான் ஸ்டார்டர் ரிப்போர்ட்னு கொடுத்துருவாங்க. இல்லை வந்து முதல் நோட்டீஸ்க்கே ரெஸ்பாண்ட் பண்ணி மீடியேஷன் சமரசம் நடந்து சமரச கூட்டங்கள் நடைபெற்று சமரசம் ஏற்படவில்லை என்றால், சமரசம் முறிந்து போனது, சமரசம் முயற்சிகள் முறிந்து போனன, சமரச முயற்சிகள் தோல்வி அடைந்தன அப்படின்னு ஃபெயிலியர் ரிப்போர்ட் ஒன்று கொடுத்துட்றாங்க. இது ரெண்டுல ஈதர் நான் ஸ்டார்டர் ரிப்போர்ட் அல்லது ஃபெயிலியர் ரிப்போர்ட்டை வச்சுக்கிட்டு யூ கேன் ஃபைல் அ சூட். திஸ் இஸ் த பொசிஷன். இதில் 2 more minutes. ட்ரெஜெக்டரி என்ன ஆச்சுன்னு உங்களுக்கு தெரியணும். 3/7 3/5/2018 12 வந்துருச்சு. பட் இட் டிட் நாட் ரியலி get implemented because the rules and notification kicked in only 2 months later on 3/7/2018. Between 3/7/2018 and I'll give you the date 13/10/23. Enna achin you should know. Interestingly, the same issue started again. Whether 12 capital A is mandatory or directory. Same issue started again. Multiple High Court started saying multiple views. Madras High Court took one view, Bombay High Court took another view, Calcutta High Court went as far as saying plaint should be rejected. Plaint should be rejected. And Delhi High Court took yet another view. Various High Courts were taking different views. And within the Madras High Court there were 2 views. Therefore, a full bench was constituted. Full bench was in session of the matter. So this is the broad issue that was there. The Supreme Court, 2 judgments. One is Patil automation. Patil automation. I'll give the citation. Patil automation. Supreme Court said 12 capital A is mandatory. End of matter. Then, நான் அந்த டேட் உங்களுக்கு சொன்னேன். I mentioned this date to you. 13/10/23. அது என்னன்னா, that is the date on which the Supreme Court decided Yamini Manohar's case. 13th October 2023. I'm talking about last month. I'm talking about last month. Less than a month back. 13/10/2023. Citation வந்து 2023 SEC online SC 1382. என்னன்னா issue என்னன்னா, one is Patil automation la mandatory ன்னு சொல்லிட்டாங்க. They said and the consequences rejection of plaint ன்னு சொல்லிட்டாங்க. அதுக்கு பிறகும் there was a raging debate. என்னன்னா, suppose you are the plaintiff, you want to bypass this mediation, you don't want to go to the mediation center, you want to bypass this mediation, simply file one IA, file a suit with the IA, say order 38 rule 5 ABJ application, or simple ABJ application. ஏதோ ஒரு அவருக்கு இருக்கிற ஒரு சொத்தை ஈஸியை வாங்கி அது என்கம்பரன்ஸ் ஆகிடும் சொல்லி, இல்லை simply ask for an injunction not to alienate, an injunction not to alienate the movable properties, computer, table, chair, wall clock in the office of the defendant, not to alienate injunction. Then one can say, I have filed an interlocutory application, I am seeking urgent interim relief, therefore I need not resort to 12A. Then who decides whether it is really urgent interim relief or merely a frivolous application which has been filed for the purpose of getting over 12A? இங்க ஒரு விஷயம் நீங்க கன்ஃபியூஸ் பண்ணிக்க கூடாது. இத கோர்ட் டிசைட் பண்ணலாமா இல்ல plaintiff? The plaintiff is the master of the plaint and plaintiff files an IA. The issue, the dispute was, the dispute, the debate was whether the court will decide or what the plaintiff says is final. In Yamini Manohar, it was concluded that the court will decide. The court can say, look at the IA and say, sorry, this is not urgent interim relief. And there is also the term contemplate used there. Plaintiff has not contemplated urgent interim relief. What is urgent interim relief has been explained in great detail in Vardhan's case. Vardhan and Changmark one and one more judgment. Vardhan is the lead case. I'll give the citation and ask them to circulate it to you. What is urgent interim relief? How do you test it? What is contemplation also has been explained. You don't have to worry too much on the semantics. Long and short of it is, I'll give you an example. Suppose we will forget this illustration. Let's take this illustration itself. In the illustration I continue பண்ணுவோம். Let us assume that the builder has given a performance bank guarantee. இத வந்து நீங்க land hand over பண்ணதுல இருந்து 12 மாதங்களுக்குள்ள நான் கட்டி கொடுத்துறேன். அப்படி இல்லன்னா அதுக்காக performance bank guarantee கொடுக்கறாரு. சே ஒரு கோடி ரூபாய்க்கு performance bank guarantee கொடுத்திருக்காரு. Suppose the plaintiff issues a notice saying, I am going to invoke the bank guarantee on day after tomorrow. Then the defendant may rush to the court. In that case, the defendant meaning the noticee, I am not saying defendant, the noticee, the builder may rush to the court. There it will be urgent interim relief, because if the bank guarantee is invoked, that's the end of the road for him. Whereas a simple ABJ application or a simple application saying not to alienate the movable properties and effects will not tantamount to urgent interim relief. That will be decided only by the court. Therefore, please be very cautious. நீங்க அர்ஜென்ட் இன்டரிம் ரிலீஃப் இல்லைன்னா தான் 12A போகணும்னு சொல்லி சிம்பிளா ஏதாவது ஒரு ஐஏவை போட்டு சூட்டை தாக்கல் பண்ணிடாதீங்க. Please go through Yamini Manohar 2023 SEC online, SC 1382. Please go through Bharathan. Please go through Patil Automation. And you know, you don't have to even go through, you know whether there is, it is emergent, whether there is imminence, whether there is urgency, is what the plaintiff knows. No difficulty about it. If you really think, I gave the bank guarantee example. If you have received a notice, if your client has received a notice saying that the bank guarantee will be invoked by, I am saying, say by 1/12/2023, can you wait for 3 months? End of matter. So you can seek urgent interim relief. In the court, the test பண்ணும்போது whether they are granting the interim order or not is another question. The test is not whether the plaintiff or the applicant plaintiff will be entitled to interim relief or not. Court will only prima facie test whether this is an urgent interim relief or just to get over 12A. Thereafter, the court may ultimately not give you ex parte order also. They are two different things. Don't get confused between these two. The court may say, all right, there is imminence shown, there is urgency, number the suit, take it on file. Ultimately, the court may not grant interim order, the court may order notice. That's a different matter altogether. Therefore, this 12A is very, very important. That has been concluded. Now, there is another subject which is of importance. That would be 21C 17. 21C and the 21 வகைப்பாடுகள் இருக்கு இல்லையா, அதுல 17 is simply IPR matters, intellectual property matters. Intellectual property matters அப்படின்னா you don't have to unduly get perturbed about what this is. Effectively, there are 6 statutes. Effectively, there are 6 statutes. Trademarks Act 1999, வணிக குறியீடுகள் சட்டம் 1999, Patents Act 1970, காப்புரிமை சட்டம், Copyright Act 1957, பதிப்புரிமை சட்டம், Designs Act 2000, வடிவமைப்பு உரிமை சட்டம், Geographical Indications of Goods Registration and Protection Act 1999, புவிசார் குறியீடு சட்டம், Protection of Plant Varieties and Farmers Rights Act, தாவர வகைகள் பாதுகாப்பு மற்றும் விவசாயிகள் உரிமை சட்டம், Plant Varieties, PVP Act. இவ்வளவுதான். இதுல invariably Trademarks Act and Copyright Act is what is widely invoked. Or more than 70% of the IPR suits are, I'm just giving you a thumb rule. I've not done a statistical analysis on that. I'm just giving you a thumb rule based on my experience, which is 7 years old. So I've not done any recent. So it should be about 70% should be Trademarks Act and Copyright. The remaining 4 statutes are not much invoked. They may constitute for the remaining 30% of the IPR litigation. Idhula vanda, it will straight away go to the commercial division as far as the High Court is concerned. And it need not be of specified value. It need not be of specified value. But commercial court la and the provision illa. Therefore, if it is a trademark suit of value 2 lakhs, it will still be heard by the district judge. You might ask, 2 lakh ரூபாய் வேல்யூ எப்படி டிஸ்ட்ரிக்ட் ஜட்ஜ் விசாரிப்பாரு? டிஸ்ட்ரிக்ட் முன்சிபல் கிட்ட தானே போகணும். சூட்டு வேல்யூ 2 lakh ரூபாய்னா எப்படி டிஸ்ட்ரிக்ட் ஜட்ஜ் கிட்ட போகும் அப்படின்னு சொல்லி நீங்க கேட்கலாம். வெரி சிம்பிள். in all these 6 statutes, this is something which you should know, all these 6 statutes which I referred to now, Trademarks Act, Copyright Act, Patents Act, Designs Act, GI, Geographical Indications Act, PVP, Plant Varieties Act, Trademarks Act, Copyright Act, Designs Act, Patents Act, GI and PVP. All these 6 statutes, there is one provision which says this suit shall not be filed in a court inferior to that of a district court. Only a district judge can hear any suit arising out of these 6 statutes. Therefore, value 2 லட்சமா இருக்கலாம், it may not even qualify, but still it will go only to the district court. Value 5 லட்சமா இருக்கலாம், அப்பவும் it has to go only before the district court. இந்த 6 சட்டங்கள் மாத்திரம். So அது மாத்திரம் பாத்தீங்கன்னா கன்ஃபியூஸ் ஆயிடாதீங்க. How did it come to the district court? அந்த 6 சட்டங்கள்லயும் it is under 21C17. அது மாத்திரம் பார்த்தலாம் ஒரு முறை. 21C பார்த்தோம் நம்ம. அந்த 21 வகைப்பாடுகளையும் பார்த்தோம். 21C. Once again we'll read. 2 is definitions. 1 is in this act unless the context otherwise requires. C is commercial dispute within courts. Means a dispute arising out of. I am slithering through 1 to 16 and 17 says intellectual property rights relating to registered and unregistered trademarks, copyright, patent, design, domain names, geographical indications and semiconductor integrated circuits. So it will be a commercial court suit straight away, assuming for a moment it is less than the value of 3 lakhs also, it will be only before the district court. For instance, in Trademarks Act, the provision which says it should not be filed in a court inferior to that of a district court is 134. In Copyright Act it is 62. In Designs Act is section 22. எல்லா இந்த 6 இதுலயுமே இந்த provision இருக்கு. அதனால you need not worry about that. This much about section 12A, filing, and then about the amendments and simple procedural law. And at the risk of repetition, I am saying the 7 statutes which you have been repeatedly deploying in civil suits, namely Indian Contract Act 1872, Specific Relief Act 1963, Transfer of Property Act 1882, Indian Easements Act 1882, Partition Act 1893, Sale of Goods Act 1930 and Negotiable Instruments Act 1881. No change when it comes to commercial court. The substantive law is the same. Now we will just quickly run through what are the amendments and I will close with that. I will request your office bearers to circulate this, and I've given, as regards the case laws, I have given the citation only for Yamini Manohar 2023 SCC online, SC 1382, decided less than a month ago on 13th October 2023. The Patil automation and the Vardhan irka 1028, please make a note of it. Paragraphs 97 onwards are very important, and the other one is Vardhan. Now we'll just run through this PPT. I'm not going to spend time on each one of the slides. 16 slides தான் இருக்கு. We'll run through this. Commercial Courts Act 2015, பாத்தீங்கன்னா Act 4 of 2016 இருக்கும். You might wonder 2016 சட்டம் எப்படி 2015 இருந்து அமலுக்கு வந்ததுன்னு you may have a doubt. Please bear in mind it originally came in as an ordinance. Ordinance ஆக வந்தது, அதுக்கு பிறகு சட்டமாக இயற்றப்பட்டது. Therefore came into force on 23/10/2015. 2014 தான் சட்டமாச்சு. That is one. No. Number 2. The amendment which I was mentioning to you. Commercial Courts Act was amended by Act 28 of 2018, dated 21/8/2018, but with retrospective effect from 3/5/2018. அதனால தான் 3/5/2018 இருந்து there was an amendment to the Commercial Codes Act. அதாவது முக்கியமான amendment 1 கோடி ரூபாயாக இருந்தது 3 லட்சமா குறைச்சாங்க. 12 capital A கொண்டு வந்தாங்க. Some other amendments are there that is not very relevant. 12 capital A pre-institution mediation கொண்டு வந்தாங்க. அதை பத்தி நம்ம இப்போ பார்த்தோம். And number 2, specified value 1 கோடி ரூபாயாக இருந்தது 3 லட்சமா குறைச்சாங்க. Simple. Then Commercial Codes Act in a nutshell. CPC has 158 sections, 52 orders in Schedule 1 and 8 appendices. Section 16 of the Commercial Codes Act 2015 amends 3 sections, 10 orders and adds 1 appendix to the existing 8 appendices of CPC in its application to the commercial codes. அது என்னன்னு இப்ப பார்க்க போறோம் as we run through the slides. 3 provisions of CPC made inapplicable to commercial codes. Pre-institution mediation is mandatory. இவ்வளவுதான். Now with regard to, you might wonder, in the 3 sections 52 order ஒரு appendix and 8 appendicesல 3 sections 10 orders and 1 appendix added இல்லையா? Can I get it in a nutshell in some part of the Commercial Codes Act அப்படினு கேட்டிங்கனா yes. Section 16 and schedule, that's all. That is the act itself. I am trying to simplify. I am just trying to simplify and tell you there is nothing much to fear. Please come to section 16. Section 16 is under chapter 6 and it is a standalone provision under chapter 6, a standalone provision. Amendments to the Code of Civil Procedure 1908 in its application to commercial disputes. 1. The provisions of the Code of Civil Procedure 1908, 5 of 1908 shall, in their application to any suit in respect of a commercial dispute of a specified value, stand amended in the manner specified in the schedule. In the schedule போனீங்கன்னா, இந்த ஆக்டினுடைய ஷெட்யூலுக்கு போனீங்கன்னா, இந்த 3 sections 10 orders ஒரு appendix என்னன்னு தெரிஞ்சிரும் உங்களுக்கு. அவ்வளவுதான். 2. The commercial division and commercial court, ரெண்டுத்துக்கும் உள்ள வித்தியாசம் பார்த்துட்டோம். Commercial division na high court, commercial court na district court. Commercial division and commercial court shall follow the provisions of the Code of Civil Procedure 1908, 5 of 1908, as amended by this act, in the trial of a suit in respect of a commercial dispute of specified value. Other section 6, 21C plus 21I. 21C plus 21I. 21C ல உள்ள 21 ல ஏதாவது ஒரு வகைப்பாடா இருக்கணும் plus 21I இருக்கணும். 3. Where any provision of the rule of jurisdictional high court or any amendment to the Code of Civil Procedure 1908 by the state government is in conflict with the provisions of the Code of Civil Procedure 1908 as amended by this act, the provisions of the Code of Civil Procedure as amended by this act shall prevail. Special statute, simple, special statute, it prevails. It's only stating the obvious. Therefore, in the ரெண்டாவது bullet point உங்களுக்கு எங்க கிடைக்குதுன்னு கேட்டிங்கன்னா section 16 and the schedule, that is the soul of this statute. That's all. Section 16 and the schedule is the soul of the statutes. This statute, sorry. And pre-institution mediation mandatory நம்ம பார்த்துட்டோம். Now most important provisions னு ஒரு லிஸ்ட் கொடுத்துட்டேன். Next slide. Simple. Section 6 jurisdiction பார்த்துட்டோம். A commercial dispute of specified value. A commercial dispute of specified value. அடுத்து 21C definition of commercial dispute. 21 plus 1 22 வகைப்பாடுகள் அதுவும் பார்த்துட்டோம். Section 21I read with 12 definition of specified value அதுவும் பார்த்துட்டோம். 1 கோடி ரூபாயா இருந்தது 23/10/2015, பிறகு 3/5/2018 இருந்து 3 லட்சம் ஆயிடுச்சு 21I. Then 12 capital A PIM, pre-institution mediation. Commercial Courts Pre-Institution Mediation and Settlement Rules 2018 dated 3/7/2018 made by central government. Notification also made DLSASC, that is also on the same day. Then lastly section 16 read with schedule. Other soul of the matter, meat of the matter, heart of the matter, whichever expression you would like to choose. This is simple, soul of the matter, that's all. Then we will quickly run through what are the amendments. amended sections இந்த மூணு செக்ஷனும் ஒரே ஸ்லைட்ல கொடுத்துட்டேன். 26(2) inserted, 35 substituted, 35(a)(2) omitted. இதுல ஒரு எக்ஸாம்பிள் மட்டும் சொல்றேன். For instance, in the 35(a)(2) omitted na 35(A) you all know exemplary cost. We call it exemplary cost. அது வந்து limit was 3000. is under CPC 35(A)(2) கீழ ஆனா removed. இங்க 10 லட்சம் ரூபாய் exemplary cost எல்லாம் போட்டுருக்கேன். என்ன வேணா போடலாம் exemplary cost. No difficulty about it. No upper limit. Another point is கொஞ்சம் slightly இது என்னன்னா another amendment to 35 costல interesting amendment மட்டும் சொல்லிடுறேன். Complete discretion of the court to impose costs on any of the parties to the suit. இதுல என்னன்னா cost can be imposed even on a successful party. Cost can be imposed even on a successful party. For instance, plaintiff files a suit. Let us say இந்த இதுலயே வந்து damagesum கேக்குறாருன்னு வெச்சுக்கோங்க. Your specific relief granted, injunction granted, damages dismissed. Damages is completely frivolous னு வெச்சுக்கோங்க. plaintiff-க்கும் காஸ்ட் போடலாம். That is how it has been amended. Plaintiff succeeded, he got the decree. ஒரு லிம்பு தான். இது எதுக்குன்னா ஃப்ரிவலஸா எதுவும் போடக்கூடாது, சேர்த்து விடக்கூடாது, போட்டு விடுவோம் அப்படின்னு சொல்லிட்டு ஒன்றும் டாக்குமெண்ட் கிடையாது. ஆனால் டேமேஜஸ் கிளைம் பண்ணுறது, லிக்விடேட்டட் டேமேஜஸ் கிடையாது. டேமேஜஸ் யூ ஹேவ் டு ப்ரூவ் டு த ஹில்ட். ஒன்றும் இல்லை, ஒரு டேமேஜஸ் கேட்டு விடுறது ஒரு 10 லட்ச ரூபா. அதை வந்து எலிமினேட் பண்ணுறதுக்காக இந்த மாதிரி ப்ரொவிஷன்ஸ் ஹேவ் கம். இன்ட்ரெஸ்டிங் ஆஸ்பெக்ட் இஸ் ஈவன் ஆன் அ சக்சஸ்ஃபுல் பார்ட்டி சூட் டிக்ரீட், பட் யூ ஆர் multed with cost, not with cost. So you will not be entitled to இது கூட பண்ணலாம். அது இந்த மாதிரி அமெண்ட்மெண்ட்டினுடைய இது. Then order 5 issue and service of summons. இதுவும் இந்த இன்னொரு ப்ரொவிஷன் தான். Written statement to be filed within 30 days. filled இருக்கு, சாரி கொஞ்சம் அவசரமா ரெடி பண்ணதுல filed. I keep correcting, so I have to correct myself too. I have no my apologies for that. 30 days from service of summons, thereafter 90 days extra, but with leave of court can impose costs. அதுதான் இப்போ வந்து mandatory ஆக்கிட்டாங்க. SGS அந்த SGS கான்ட்ராக்ட்ஸும் சைட்டேஷன் கொடுத்துறேன். இது ஏற்கனவே இருந்தது. This is what I said, ஏற்கனவே 90 days CPCல இருக்கிறது. Then pleadings, இதெல்லாம் purely procedural, specific format. அதில் தான் அந்த I வரும். Statement of truth I-ல we leave it at that. I don't want to go into that aspect of the matter. Then order 7 plaint to disclose detail when interest is sought by plaintiff in the suit, specific details to avoid vague governments. Pleadings ரொம்ப specific-ஆ இருக்கணும் அப்படிங்கிறது. Then written statement. இதில் again you will find that 90 days and 30 days rule, 120 days rule. Then next slide 10. Fully substituted discovery, disclosure and inspection of documents, etc. இது ஏற்கனவே இருக்கா இல்லையா சிபிசியில்? நம்ம ஃபாலோ பண்றது இல்லை. இருக்கா இல்லையா? நம்ம ஃபாலோ பண்றது இல்லை. This is nothing new. நம்ம வந்து இந்த டிஸ்கவரி ஆஃப் இதில் வந்து it has become mandatory. CMH court management hearing ஒன்று வச்சு இந்த affidavits admission and denial already CPCல இருக்கு. There is nothing new that because we have been we have been observing it on the breach rather than observing it on the compliance, therefore now this has made it mandatory. அவ்வளவுதான். Then 13 capital A summary judgment. இது மாத்திரம் கொஞ்சம் ஒரு நிமிஷம் we'll spend, I can go on for another 5 minutes இல்லமா? We'll just இது மாத்திரம் கொஞ்சம் இந்த சம்மரி சூட் ஆர்டர் 37 அண்டர் சாப்டர் சூட்டும் இதுவும் கன்ஃபியூஸ் பண்ணிக்காதீங்க. இதுக்கும் அண்டர் சாப்டர் சூட் ஆர்டர் 37க்கும் சம்பந்தமே இல்லை. சம்மரி சூட் வேற, இது வேற. இது சம்மரி ஜட்ஜ்மெண்ட். சம்மரி ஜட்ஜ்மெண்ட்ங்கிறது என்னன்னா லாங் அண்ட் ஷார்ட் ஆஃப் இட், ஐ எம் நாட் ரீடிங் த ப்ரொவிஷன் அண்ட் போரிங் யூ, நீங்க படிச்சு பார்த்துக்கோங்க. லாங் அண்ட் ஷார்ட் ஆஃப் இட் என்னன்னா, in a commercial court the court has the power to either decree or dismiss a suit without trial. It can either decree or dismiss a suit without trial. இதுக்கு என்ன டெஸ்ட் அப்படின்னு பார்த்தீங்கன்னா, for instance, I'm decreeing the suit without trial னு வச்சுக்கோங்க. After some arguments, after seeing the pleadings, if the court is convinced that the defendant has no real chance of defending the suit, it can be decreed. Likewise, if the court is convinced that the plaintiff has no real chance of a decree, it can dismiss the suit. Broadly, இதில் நிறைய நுவான்சஸ்லாம் இருக்குது, அதுக்குள்ள ரொம்ப டீட்டெயில்டாக போகணும்னா ப்ராட்லி இந்த சம்மரி சூட்டையும் சம்மரி ஜட்மெண்ட்டையும் கன்ஃபியூஸ் பண்ணிக்காதீங்கன்றதுக்காக இப்படி ஒரு ப்ரொவிஷன் இருக்குது. ட்ரையலே இல்லாமல் ஜட்மெண்ட் சொல்லலாம், அதுக்கும் ப்ரொவிஷன் இருக்குது. செவரல் ஜட்மெண்ட்ஸ் ஹவ் பீன் given on the original side. I can tell you for sure, and it has gone up to the Supreme Court also, and it has stood the test of time. Then 15 capital A, இதுதான் very very important. இது வந்து CMH, to be held within 4 weeks from admission and denial of documents, to have a time-bound trial, time-bound manner and court-monitored trial, so that case can be completed at the earliest. என்னன்னா இந்த கேஸ் மேனேஜ்மெண்ட் ஹியரிங்க்கு லிஸ்ட் பண்ணும்போது you have to give the list of witnesses. அது ஏற்கனவே கொடுக்கணும், நம்ம கொடுக்கறது இல்லை, இப்போ கொடுக்கணும், கொடுத்தாகணும். CMHல ரெண்டு சைடும் லிஸ்ட் ஆஃப் விட்னஸஸ்ல இவர் என்ன சொல்ல போறாரு, அவர் என்ன சொல்ல போறாரு. So then what is the nature of evidence? All right, he will be cross-examined for 1 hour, this man will be cross-examined for 2 hours, and நீங்க by the clock fix பண்ணி you can even appoint a commissioner separately to record the evidence, a retired judge or somebody to record the evidence, and the court can go into it. Allowed. Another point is, இப்போ ஒரு provision கொண்டு வந்துட்டாங்க. For instance, eschew evidence-னா எந்த provision கிட்ட போடுவீங்க? CPC-ல ரெகுலராக ஃபைல் பண்ணுறோம், எதுக்கிட்ட ஃபைல் பண்ணுவீங்க? You want to eschew deposition, no provision, correct. ஆனால் ஃபைல் பண்ணுறீங்கல்ல, எதுக்கிட்ட ஃபைல் பண்ணுறீங்க? 151. இப்போ if it is a commercial court, there is a specific provision, redaction. There is a provision for redaction. அதை கோர்ட்டே பண்ணலாம், கோர்ட்டே can do that. இந்த 3 செக்ஷன்ஸ் 10 ஆர்டர்லேயே அது வந்துடுது. You don't have to worry. இது புதுசாக நான் எதுவும் சொல்ல, இந்த 3 செக்ஷன் 10 ஆர்டர்லேயே வந்து இந்த ஸ்லைட்ஸ்லேயே இருக்கும். ரிடக்ஷனுக்கு ஒரு ஸ்பெசிஃபிக் ப்ரொவிஷன் இருக்கு. உதாரணம் சொல்கிறேன். சப்போஸ் ஐ எம் த பிளைன்டிஃப், ஐ வாண்ட் டு லெட் இன் எவிடன்ஸ் த்ரூ 2 persons, 2 பேரை விசாரிக்கணும்னு சொல்கிறேன்னு வச்சுக்கோங்க. ஒருத்தர் வந்து டெக்னிக்கல் பர்சன், இன்னொருத்தர் ஃபைனான்ஸ் பர்சன். டெக்னிக்கல் பர்சன் வில் டாக் ஒன்லி அபவுட் த டெக்னிக்கல் ஆஸ்பெக்ட்ஸ் ஆஃப் த மேட்டர். அவர் ஃபைனான்ஷியல் ஆஸ்பெக்ட் எல்லாம் ஃபுல்லாக பேசுறது, யூ கேன் சே ரிடாக்ட். அதே மாதிரி ஃபைனான்ஸ் பர்சன் டெக்னிக்கல் ஆஸ்பெக்ட்ஸை பேசுறது. இந்த ப்ரூஃப் எஃபிடவிட்டையே ரிடாக்ட் பண்ணலாம். ஏன்னா இப்போ ப்ரூஃப் எஃபிடவிட்டுங்கிறது ஆக்டிவ் வாய்ஸ் பாசிவ் வாய்ஸ் வெரிஃபிகேஷனுக்கு பதிலாக ஜூரட்டு போட்டுறீங்க. ஃபர்ஸ்ட் பர்சனை வந்து ஆக்டிவ் வாய்ஸ் பாசிவ் வாய்ஸ் ஆக்கி அவர்மெண்ட்ஸை கீழே வெரிஃபிகேஷனுக்கு பதிலாக ஜூரட்டு போட்டுறீங்க. பிளைண்ட் அது கிடையாது. அந்த காலத்தில் முதல் விசாரணை இருக்கும், பெட்டியில் ஏற்றி எது தேவையோ அது வரைக்கும் தான் முதல் விசாரணை. ப்ரூஃப் எஃபிடவிட் கிடையாது. அதான் இஸ் கமிங் பேக் நவ் இன் த ஃபார்ம் ஆஃப் ரிடக்ஷன். எதுக்கு இதெல்லாம் கேட்குறீங்க? முதல் விசாரணைன்னா எதெல்லாம் அட்மிட்டடோ அது வரைக்கும் லீடிங் கொஸ்டின் கேட்டுக்கிட்டே வருவோம். கடகடன்னு உங்கள் பேர் என்ன, சூட் இது, இதானே இவர் எதிர் நேராக இது தானே சொல்கிறீங்க, இதானே உங்கள் இதெல்லாம் அட்மிஷன், இதெல்லாம் வந்து அட்மிட்டட், ஒன்றும் டிஸ்பியூட் இல்லை. அது வரைக்கும் லீடிங் கொஸ்டின்ஸ். அதுக்கப்புறம் லீடிங் கொஸ்டின்ஸ் வில் ஸ்டாப் and you start asking questions which are not leading questions and complete the examination in chief. இப்போ examination in chief கிடையாது, proof affidavit concept வந்தது தான் இந்த active passive voice which I was telling you. Anyway, now there is a provision for redaction also. Then next is hearing of suits and examination of witnesses. ஒரு interesting very very interesting இது written arguments க்கு provision கொடுத்துட்டாங்க. That is before oral arguments. Before oral arguments. So once you file the written arguments, you can pin down, say this is what you have said. Sorry, restrict your arguments to this. You can't suddenly take off in the hearing. You can't walk into a hearing. You have to go fully to prepared for a hearing. The idea is to condense it. The idea is to minimize the time taken. Not endlessly argue for days together on a simple injunction, bare injunction suit. That should not be the objective. Inserted new rules and in affidavit, idella procedural. And then order 20 substituted judgment and decree. and then provisions of CPC made inapplicable. 3 provisions made inapplicable. I said 3 provisions of CPC have been made inapplicable. Slide 16 potukalama. Slide 16 potukalam. These are the 3 provisions of CPC which have been made inapplicable. Order 13, Rule 1, Order 7, Rule 14, Order 8, Rule 1A. We can have one more session also. We can go into each one of this another subject to, if it is interesting, if you feel commercial courts are coming in a big way. We already have 7 constituted commercial courts. From the data, I find that Madurai District Court has sufficient number of commercial courts. So though you don't have an original side, but you have a commercial appellate division. You have a commercial appellate division. On the court, where appeals will go to the commercial appellate division. So therefore, if you feel it is interesting, it is useful, we can have one more interaction on these aspects of the matter. That is all I complete with these 16 provisions. If anybody has any specific question, please feel free to ask. Yes. You can file an application or make an oral request. The registry itself should make. But otherwise 15(4) says, section 15 subsection 4 says, all pending matters should be transferred. No. 12A is only before filing and it is prospective. And the prospective date you partal automation solitanga. Date of judgment Balaji Patare, but adliye date of fix pannitanga. They said 17/8/22 solitanga. Para 100 la nenikiren. 17/8/22 solitanga. So therefore that is not a yes sir.
Notice. Prior to institution of mediation is absolutely necessary.
Yes.
Then what is the timeline between the sending
இல்ல absolutely essential na mandatory சொல்ல நீங்க suit notice கொடுக்காம கூட suit போடலாம், but you should be able to convince the court that I don't even have time to give suit notice.
Then your lordship has stated that the court has to decide whether filing of an interim application is necessary or not.
Yes.
In that case,
No, whether filing of an when you file an interim relief, whether it is contemplation of urgent interim relief or not is a question which the court will decide.
yes. Suppose the court decides it is not necessary and
It's not necessary. The contemplation of urgent interim relief, there is no proper contemplation, no urgent relief is required, the court decide panna. அதாவது நீங்க ப்ரீ இன்ஸ்டிடியூஷன் மீடியேஷனுக்கு போகாம சூட் ஃபைல் பண்ணிடுறீங்க அப்போ வந்து கோர்ட் டெஸ்ட் பண்ணுவாங்க.
Then in that case, if the respondent or the defendant has alienated the property in the meanwhile, what will happen to the alienation?
No, this is very simple. This pendants will definitely not apply. Section 52 will not come into play. There will be no pendency of suit. That is a call which the court takes. If the court finds there is urgent interim relief,
The plaintiff or the petitioner will be put to difficulties.
that is for you to convince the court. You have to convince the court that if I wait for 3 months,
If I am not able to convince the court,
yes,
the respondent is
file an appeal. File an appeal.
Suppose in the meantime,
Yes.
if the mistake is done, what will happen to the unfortunate petitioner and the plaintiff?
I'm asking you. Your IA is dismissed, your suit is dismissed. You in between, before you file appeal, there is a alienation. Enna பண்ணுவீங்க? Same kind of a situation. It is a judicial decision.
And the party has to suffer.
Sorry,
And the party has to suffer.
party can benefit also. It depends on what. It depends on. Yes, Mr. Maligan is okay.
Section 12, invoking section 12A, you cannot have the benefit of 22 of the DPI.
Sorry, invoking 12A?
Section 12A,
Ah.
invoke பண்ணதுனால 52 to TP Act benefit varada.
Bharat. As of now, there is no law on that. No, our case he files a suit with IA. The court, you are not able to convince the court that the IA is contemplation of urgent interim relief. Then the consequences, court will reject your plaint. And you know, rejection of plaint is not a res judicata attracta. Order 7, Rule 13. Rule 13 it is same. You can file another suit to the same after exhausting the pre-institution mediation. அந்த மாதிரி ரிஜெக்ட் ஆகி நீங்க ப்ரீ இன்ஸ்டிடியூஷன் மீடியேஷன் பண்ணிட்டு இருக்கும்போது 52 ரிஸ்பெண்டன்ஸ் அப்ளை ஆகணும். As of now there is no provision in that direction.
Mediation ப்ரீ இன்ஸ்டிடியூஷன் மீடியேஷன் வரல. லேட்டரல் ஸ்டேஜ்ல அந்த மீடியேஷன் அவைல் பண்ணிக்கலாம்.
Oh yes, 89 is always available. 89 is always available. That doesn't mean நீங்க urgent interim relief போடுறீங்க, suit is entertained, but ana interim order கொடுக்கல, notice goes, there are also you can go for mediation. Any stage, 89 like any other suit, 89 is available. Yes.
Mediation respondent, but not paid. In that case, whether a decree will be based on mediation before the institution of the proceedings in the court.
Good, you asked that. 12A subsection 5 is the answer. We just read it quickly. Good, you ask that. When normally mediation la ஒரு settlement arrive ஆனா அந்த settlement court la file பண்ணி the court pass a decree, only then it becomes enforceable. ஆனா இங்க 12A ல நீங்க pre institution mediation க்கு போய் if a settlement is arrived at, that settlement becomes an arbitral award. Arbitral award is a decree of the court, as you are all aware. It can be enforced under section 36 of the Arbitration and Conciliation Act 1996. One nimsham paathala, it's a very important question which you flagged. 12A 5 is the answer. 12 capital A subsection 5 is the answer. 12 capital A pre-institution mediation and settlement. இப்ப படிச்சோம் 1, 2, 3 la skip பண்ணி let us go to 5. The settlement arrived at under this section shall have the same status and effect as if it is an arbitral award on agreed terms under subsection 4 of section 30 of the Arbitration and Conciliation Act 1996. Therefore, once you resort to 12A of the Commercial Courts Act and a settlement is arrived at, that settlement per se becomes an arbitral award. 1. 2. It becomes a consent arbitral award. Section 30 subsection 4 of the Arbitration Act provides for arbitral award on agreed terms, consent decree, effectively consent decree, and it becomes an arbitral award within the meaning of section 30 subsection 4 owing to 12A5. So it can be enforced. நீங்க உட்கார்ந்து கேளுங்க, ப்ளீஸ் உட்கார்ந்து கேளுங்க, no difficulty. Yes, he can even participate in the trial. Cross examination பண்ணலாம். But cross examination பண்ணும்போது pleadings எல்லாம் நீங்க பண்ண இருக்கிறத வச்சு பண்ணலாம். அவ்வளோ. Yes, basically you should perambulate within the pleadings, but he will continue to participate in the trial. You can even cross-examine the witnesses. Adala well settled, no difficulty about it. Obviously you can argue on the point of law also. Suppose adu related சாட்சியிட்ட ஒரு கேள்வி கேட்கணும், கேட்கலாம், நீங்க நிச்சயமா கேட்கலாம். கிராஸ் ரைட் இருக்கு உங்களுக்கு.
If I have a suit where I may not require an urgent interim order,
yes,
but my limitation is about to expire,
yes, then
can we take that the pre-mediation, pre-institution mediation,
yes,
itself will be amounting to institution of the
no, it doesn't.
So in that case, if I go for a pre-mediation institution,
yes,
I will be the suit, when I file the suit, it will be rejected for limitation.
You have to necessarily file a suit and say if I resort to 12A, this difficulty arises.
Because
What you can do, what you can probably do is, this has not been tested, partly automatically they make a distinction between institution of, this presentation of suit and institution of suit. Probably, you know the distinction. You have to necessarily present and you have to make this request. It doesn't say limited. 12A, there is nothing to say that.
because if then the suit will also get rejected.
Correct. It will be barred and the court will examine that even if the defendant doesn't raise it because of Section 3 of the Limitation Act. That has not been tested. This 52, which Mr. Armon and Mr. Vadivel raised, and this what you are raising limitation, these two have not been tested. It's a toddler, no? It's a toddler. So it's yet to be tested. Sorry?
I said it will take time.
It will take time. It's a toddler. It's not been tested. Let me tell you, there is no, our settlement வந்துருது அது அவர் கொடுக்கல அப்புறம் மீடியேஷன் படி கொடுக்கலன்னா என்ன பண்றது அக்ரிமெண்ட் படினா straight away the answer is provision இருக்கு. It becomes an arbitral award. You can enforce the arbitral award by resorting to section 36 of the Arbitration Act as if it is a decree. அந்த மாதிரி டைரக்ட்டா provision இல்ல. It has to be tested both for 52 and for Limitation Act. Yes, please.
Is act applied to for India only or extended to international aspect?
As of now, it is only in India, but all over the world, many countries, commercial courts are there, commercial courts acts are there, and interestingly, we have borrowed heavily from England. There it is called law merchants, and it started in 1895. 1895 law merchants in Tanya, they had a court. I think Adil was googling it to check whether I am saying whether what I am saying is correct. Irka? 1895. The London Guildhall. It was where I think Justice who sat 1895. We borrowed heavily from England. Nariya countries irukku. Even Russia has a commercial court. Recently we had this ENCA judgment which is on arbitration. That also you will see it has a commercial court. Most of the other jurisdictions have commercial courts and there is a separate act. This act is for India. I am so happy there are so many questions which means I made some impact. Parties can make an application. You can make an application. Normal appeal. Your revision will be available. CMA entrance, CMA. All that is normal. CPC is a change. Excepting these 3 sections, 10 orders, and one appendix being added. No change in CPC. That's why IA injection under CMA, CRP, and CRP of course amended 115. That's why article 227 use extensive. 115 narrowed down, 227 so therefore, that's same. That's same, so revision is available. Definitely, it's an application. A plaintiff can file an application for summary judgment decree, a defendant can file for summary judgment dismissal, and that will be heard like any other, and the court will decide. Order 13 capital A, amended by Order 13 capital A, has been introduced into CPC by this amendment. Schedule, it will take a lot of time if we go into it. I have said that here, Order 11, and then you will find, see schedule, insertion of new Order 13 capital A. After Order 13 of the code, இப்போ CPC எடுத்து பாத்தீங்கன்னா Order 13 தான் இருக்கும். Order 13 capital A இருக்காது. Commercial Codes Amendment மூலமா 13 capital A கொண்டு வந்திருக்காங்க. After Order 13 of the code, the following order shall be inserted. Order 13 capital A, summary judgment. Scope and classes of suits to which this order applies. அது பாத்தீங்கன்னா இதெல்லாம் வரும். Order 13 capital A. Sir, you wanted to ask something. Yes, please.
Regarding the court,
Yes.
another
another one. He said there are 3 exceptions when you file the original document.
Sorry,
3 exceptions regarding original document. That was a briefly situated for that.
We'll have it in another session. Court fee வந்து என்ன கேக்குறீங்க? எப்படி கம்ப்யூட் பண்றதுன்னு கேக்குறீங்களா?
Whether they have a fixed court fee.
இல்ல, same Tamil Nadu Court Fees and Suits Valuation Act will apply. Same Tamil Nadu Court Fees and Suits Valuation Act will apply.
The second question is regarding the exceptions you said about.
That we will have for one session separately. That will take a lot of time. We may have to go into it. That is a very valid question which you have asked, but that will take a lot of time if we go into it.
And it's also a commercial dispute. Okay, because this act is a later legislation and it overrides any other law that I'm being imposed. Can I not circumvent Section 8 of the Arbitration Act?
Katla is the answer. As between 2 special statutes.
Yes, so therefore, can I not circumvent Section 8 of the Arbitration Act and take judicial recourse to...
I didn't follow the question.
If a dispute is also an arbitral dispute.
Right.
Where there is an arbitration agreement.
Correct.
At the same time, I can fit in as a commercial dispute of
Yes.
65
Yes.
So can I, because this act has, it overrides over any other legislation, obviously it includes the Arbitration Act. Can I take recourse to...
No. If it would override only when there is a conflict. Merely because you file a suit in a commercial court or a commercial division of the High Court, the defendant will not lose his right to file an application under Section 8. Section 8 of the Arbitration and Conciliation Act. That is always available to the defendant. That law is well settled. Even in a commercial court or commercial division suit, the defendant can file an application under Section 8 and say, please see, there is an arbitration agreement between us, therefore refer the matter to arbitration. So therefore, under Section 8 of the Arbitration and Conciliation Act, as you might be aware, all that the court will test is whether there is an arbitration agreement. Valid arbitration agreement kuda kadiyadu. Section 11 is the valid arbitration agreement. Whether there is an arbitration agreement. That's all. That can't be done. Any other question? Please feel free to ask. I'm not in a hurry. Only that question, it will take a lot of time if we go into the exceptions. Adanala I did not. You go through this slides or all these provisions, then reserve your questions. Then we can have one more, I won't call it lecture, one more interaction also.
And what is the implication with 80 CPC and the 3?
80 CPC dispense with the 12 dispense with the other main difference. 80 CPC rejection of plaint may not be the consequence. Inga rejection of plaint is the consequence. Other dispense with provision idhula rejection of plaint is the consequence. Adala the partial automation mandatory. Thank you very much.
தேங்க்யூ லார்ட்ஷிப். ஒரு ஆத்மாத்மான ஒரு ஈவினிங்கை கொடுத்துருக்கீங்க. உண்மையாக ரொம்ப பயனுள்ளதாக இருந்தது. நீங்கள் ஆரம்பித்த உடனே எங்களுக்கு ஒரு பில்டிங் வந்து அதில் நாங்கள் மீடியேஷனில் உட்காந்து 2 பார்ட்டியை வச்சு பேசுகிற ஒரு கற்பனை கூட வந்துருச்சு எங்களுக்கு. அப்படி ஒரு நல்ல ஒரு லெக்சர் கொடுத்தீங்க. தேங்க்யூ லார்ட்ஷிப். Now I would like call upon our Secretary Mrs. P. Krishnaveni ma'am to propose the vote of thanks.
Honorable Mr. Justice M. Sundar, Administrative Judge, Madras High Court, Madurai Bench. Honorable Mr. Justice P. B. Balaji, good evening to one and all. I consider it my privilege to propose vote of thanks on behalf of WAA. First of all, the presence of Honorable Justice Mr. M. Sundar, Administrative Judge, in spite of Lordship's busy schedule, is the reflection of the significance that is attached to the commitment to the legal fraternity. My Lord, we are inspired by your gracious presence, and my Lord, we are very much benefited by the lecture Lordship have delivered. And my Lord, I like to submit one thing on behalf of our members. It is, as rightly said by my Lord, it is more of interaction sessions than lecture series. Lord, thank you. I'd like to thank Honorable Justice P. B. Balaji and Honorable Justice R. Saktivel for their gracious presence besides their hectic schedule. I'd like to thank Jessie Jivapriya ma'am, Jayendra Patel ma'am, Dilip Kumar sir, Karpsami Pandian sir, Atif, librarian of MBHAA, Tangam Rajaram, and I'd like to thank all the women advocates who are here after 5. Sorry, I have forgotten the name of Armugam sir. Thank you, sir, for your presence. And I am very happy. And in the Mari sessions, when Nariya Nadakanun Soli, President Naketikra. And I'd like to thank our president for arranging such a good lecture series. And I'd like to thank my EC members and the staffs for ever support. Thank you, one and all. Thank you.